Welcome back. You're watching HFO-TV, co-sponsored by AMF Capital, the Janik Law Firm, the Butler Exchange Group, and the construction firm J.R. Johnson.
Welcome back to HFO-TV. I'm Greg Frick, partner here at HFO Investment Real Estate. Today we're lucky to have two partners from Janik, Ciaran, Connelly, and Chris Walters. We're going to talk a little bit about some of the eviction moratorium that was put in place during this pandemic and kind of get some clarification on that. So I want to thank you both for taking the time out to hop on one of these calls. We are practicing social distancing. We do have masks here, but we're not in the same room. So therefore, we don't have to wear them as we're talking. It makes it a little bit easier to have conversations without the mask on. So again, thanks to both of you for coming. I hope both of you are doing well and families doing okay during these kind of crazy times.
Appreciate it.
Absolutely.
So you could maybe give, and our audience again is predominantly multifamily landlords, property owners that own multifamily properties. Maybe give a summary of kind of, what is the new eviction moratorium? What does that mean for apartment property owners specifically in Oregon? And we can talk a little bit too about Washington, but let's maybe focus on the Oregon properties first.
Sure, Greg. I think everybody's heard about this moratorium, but the real source for this are a set of 4 documents really that are operative at the moment. There is the governor's executive order 20-13, and that's we'll talk about that more in a minute. There's Multnomah County Ordinance 1284, and we'll talk about that. There's Portland Ordinance 189890. And then finally, there is the Oregon Chief Justice's Order 20-006. So there's those 4 documents, and we're going to kind of go through them and give you sort of a summary of what the provisions of each of those are. But Chris, maybe broadly, if you want to talk about the nature of them as a whole.
Well, while the gravis of these documents is to suspend terminations of leases and to postpone any eviction actions, and Ciaran will talk a little bit about what can be done in the interim, there are some additional very interesting provisions, particularly with respect to the Multnomah County order, which also suspends payment of rent and defers payment of rent. And a paragraph that's tucked into the governor's order that essentially requests the tenant make partial payments, pay what they can. And we'll talk about the implications of both of those as we go along as well.
So if you're in, we have a building or, I've got a building that's in Portland, that's in Multnomah County. So I'm in the state of Oregon, I'm in Multnomah County, and I'm in Portland. Am I on all 3 of these? How does that work in terms of, what do they do?
Yeah, and we can talk about that as we go through them. Okay. I think we'll start broadly with the governor's executive order, which applies to everybody in Oregon.
Got it. Okay.
And then we'll kind of narrow it down with each of those other jurisdictions. So first, the Governor Brown's executive order 20-13 came out April 1st. And puts the moratorium into effect for 90 days, which means it would expire on June 30th this year. During that time, what the order says is that no Oregon residential landlord, cannot terminate a lease for non-payment, can't take any steps to evict a tenant, whether they're judicial steps or extrajudicial steps to evict a tenant for non-payment during those entire 60 days. So if you're looking for anything based on non-payment, and Chris will talk about what non-payment means because it's not completely intuitive. But in terms of taking any actions for non-payments, you're prohibited from doing that by this executive order for 90 days. Chris, do you want to talk about what non-payment means?
Yeah, non-payment has a funny definition in the ordinance, and it doesn't include just payment of rent, but also of late charges, utility charges, or any other service charge, or any fee that's collectible under the Residential Landlord Tenant Act. and includes for residential tenancies only termination without cause. So therefore, if your lease with your residential tenant expires, you also cannot evict them during this period.
So if my lease expires, I can't, okay, so interesting, okay. That's under the non-payment.
Exactly. That's included in the definition of non-payment.
Okay.
And just to put a little color on that includes all those definitions, those landlord excused reasons that we talked about a year or so ago under HB 608 or SB 608. All those reasons that if you want to evict somebody because you're trying to remodel the place or have to do maintenance, all of those reasons are no cause terminations that are allowed under the state statute but are prohibited as being for non-payment by this moratorium. So you can't start that process during this 90-day period.
Right.
Gotcha. Okay.
Anything in that bucket. Not true, by the way, of commercial evictions. The termination without cause provision is not in the parallel commercial eviction moratorium.
So commercial is not at all?
Commercial is only for what you would regularly call non-payment, not termination without cause.
Okay.
Right. And just one ancillary point about the executive order, and then we'll move on to the Multnomah County ordinance. There's Executive Order 20.13 sort of replaced and supplemented an earlier order, 20-11, that Governor Brown had issued, which didn't directly affect landlords, but directed law enforcement officers not to serve any notices or take any steps along those lines to enforce eviction orders. So 20.13 supersedes that, incorporates those provisions, but makes them more broad so that they apply to all landlords.
Okay, so yeah, I think we had a lot of property owners that saw that first initial one, and then maybe, so it's good we're doing this so they kind of get an update as to that there is one that superseded that, and now is kind of the one in place. So that's the state of Oregon. That's the Governor Brown's executive order for the state of Oregon, and then we have from there we've got the Multnomah County. That's
interesting. It's a parallel order. The dominoes kind of fell this way. Portland started. Multnomah County then imposed its own order, and Portland decided that Portland's order would be superseded by Multnomah County's order. The Multnomah County order originally being its ordinance number 1282. And that had a fairly elaborate scheme with proof of inability to pay, all kinds of stuff. Then the governor issued Executive Order 2013, and the county then issued its ordinance 1284. And there's a common misconception that 1284 superseded prior orders. It's a little bit more subtle. 1284, which is the current operative county order, says that it suspends enforcement of the prior order, the 1282. So we're in a state of where there are two ordinances currently operating parallel from the county, but one of them is suspended. The 1284 ordinance parallels pretty closely in language the governor's order with a couple of important distinctions. One, it applies only to residential tenancies. Two, it has a different term. And the ordinance itself doesn't say how long it is in effect. You have to kind of parse back a couple of levels to see that it apparently expires on July 10, some days after the governor's order. So query whether that 1282 and 1284 collectively apply in some way during that 10-day period. Now, this all assumes, of course, that the county doesn't further extend its own moratorium. Which is as likely as not, and the 6-month rent abatement, rent moratorium and deferral, I should say, extends from the later of the governor's order or the county's order.
They're not making it easy.
You shouldn't have to hire a lawyer to figure out how long a thing stays in effect.
No, that's okay. So that's Multnomah County, and then we have the city of Portland has their own order,
and which expressly stated it is superseded and aligned with the county's ordinance. In in the city's ordinance 189890.
And then on top of that, we then have a summary of Chief Justice order on top of that.
That's right. The Oregon Chief Justice has issued an order regarding all the court operations during this period, and there's a special section there dealing just with FED actions. And basically, what it does is it postpones all first appearances in all FED actions until after June 1st. So if you have filed an FED action for one of the non-prohibited reasons, right? You've got something that isn't non-payment that you're terminating a lease for. You can go ahead and file that today, but the court's not going to order a first appearance until after June 1st. And given how the courts are running, that it probably isn't going to be June 2nd. It may be a while after that. I should note that the Chief Justice's order does allow, if there's some compelling reason, and candidly, it probably needs to be really compelling, that the presiding judge in your county can overrule that general prohibition on scheduling anything beforehand. But I know our own presiding judge here in Multnomah County has expressed the view that it really needs to be very serious for the court to even consider not complying with that delay.
So then, with all these in place and everything kind of going on, and we have different dates, what are the tenants' obligations during this moratorium? And we kind of talked a little bit the difference between residential and commercial, but maybe you can give a little overview, kind of what that again, there's been all these orders and changing, and one comes out, another one comes out. Kind of where we are today. What is the obligation of a tenant, during a moratorium, residential tenant versus a commercial tenant?
Sure. Well, let me take the first part of that, and Chris maybe chime in afterwards. But broadly speaking, the tenant is required to first notify the landlord as soon as possible, as reasonably possible, that it will be unable to pay the full rent when due. So that's obligation on the tenant, number one. Number two is that the tenant is supposed to make partial rent payments to the extent that the tenant is financially able to do so. Now, those are both poorly defined. There's not a whole lot more detail in the statute, and there's not for residential tenants, there's not any proof of either of those things required. So query, how enforceable either of those things is. If you have a tenant that you think should be able to afford to make partial payments, but they're not, you're going to have a tough time proving that after the fact. And there's some question as to what the benefit to you would be of actually proving that they didn't comply with that portion of the executive order anyway.
Right, because you can't go to court anyway, right? I mean, you can't get a court date anyway for this. So yes.
Right. Even in litigation, months from now over this, if you're trying to argue backwards to what they should have been doing, you're going to have a tough time proving that they were financially able to. It's worth noting a couple of things that they're not obligated to do by this. Residential tenants don't have to prove any inability to pay. And they're not obligated, and this is different than a couple other places, but they're not obligated to enter into any side agreements with you. They're not required to enter into a payment plan or anything with the landlord. That's a possibility that we'll talk about in a minute, but they aren't required to do that.
There's an interesting prospective conflict, by the way, is with respect to that tenant obligation to pay, because that's in paragraph 3 of the governor's order. In paragraph 2, it states nothing in this moratorium relieves the tenant of the obligation to pay rent. Oh, and then in the next paragraph, it says tenant shall make partial payments. It's sitting there. It's an internal conflict in the order. I suggest if you put that in front of a judge and a tenant makes partial payment and gives the notice that's stated, the judge will say, well, the tenant was obligated to comply with paragraph 3. They have complied with paragraph 3. However, the tenant will not have complied with the lease because the lease says they have to make the payment in full at the first of the month.
Right.
So which is it? In fact, does paragraph 3 purport to excuse the tenant from default for making this partial payment? The governor's office has issued a FAQ, frequently asked questions statement, where they say, no, in fact, this paragraph 3 is a commitment on the tenant to perform this paragraph 3, and that, in fact, this moratorium does not excuse the tenant's obligation to pay rent, which obviously will be important later on when the moratorium is lifted and you have to figure out what the tenant's obligation is.
Got it. Okay. Now again, that's on the governor's notification, or
that's on the state.
The state one, right? Okay.
Yes, and again, once again, the county ordinance basically parallels the governor's ordinance with this very important distinction that it also gives a 6-month deferral on rent. Again,
one of the questions we ask is, where depending on where your building or your property is, that's going to change as to when you're under, or maybe put some light into that.
Sure. Just to be clear, that the executive order, the prohibition on evictions or an FED action, that's statewide,
right?
As is the chief judge's order prohibiting delaying until after June 1st any FED first appearances. But the Multnomah County ordinance applies in Multnomah County itself, and the city ordinance, which just defers to the county ordinance, says that it will apply in those portions of Portland that are not in Multnomah County. So if you're in any of the Tri-County area that's within the boundaries of Portland, you've got to comply with that Multnomah County ordinance.
So then so we're coming up to May. I mean, May 1st is coming up here. Like we talked about with various people, the tenants asking for assistance on the residential side. The numbers weren't as great as we, maybe forecasted or thought they were. That's different on the commercial side. Retail, office, and things like that. So what's the tenant? Does the tenant have to pay eventually if they come and say to the property owner, hey, I'm asking for a deferral, or depending where I am? I mean, how do you lay that out, and how does that work?
The tenant does have to pay, is contractually obligated to have to pay eventually, once again, at the end of the moratorium period under the governor's order, and at the end of 6 months after the later of the governor's order or the county order under the county ordinance. And the tenant is also prescribed under paragraph 3 of the governor's order to pay what it can.
And then I had a question, just kind of when we talked about is, you have a residential tenant that has a lease that expires in this time period. I mean, you can't, so, I mean, are you able to, do they just adhere to the same, I mean, are you putting them on a new lease? Do they just go to month with the idea terms are going to be the same? I mean, what's your recommendation to, hey, I've got, two leases that are coming out May 15th. I mean, they're inherently in. Do I raise them? I mean, what can you do? I mean, again, I don't think a lot of owners are raising rents right now anyway, but what is the obligation on that the tenant's there? And
well, nothing in the moratorium orders changes the term of the lease, and most leases have a holdover provision. The tenant doesn't leave and you don't consent to the staying on, it's a holdover, usually with a bump in rent. And of course, all of that is going to be subject to the various rent control.
Sorry, just to chime in on that a little bit. We talked, as I said last year, about SB 608, right, and its provisions about basically eliminating no-cause terminations after the first year of residency. So one interesting question that's not addressed by this order is, what if you were going to terminate an 11th month lease or something before you reach that first year that you're allowed to do as a landlord, but because of this eviction procedure, you can't. Right. Does a tenancy that, because of the moratorium, is extended beyond the first year, then qualify for the protections of longer tenancies under the state law. And that's a question that's just not addressed yet. And so you'll want to be very careful. And we'll talk about a little bit later how you can take steps to try to protect yourself and maintain the maximum amount of flexibility given the uncertainty that we're seeing.
So then we did mention that there are some, some things that are still allowed in terms of if you've got issues with a particular tenant, they're going to have to be extreme. It's going to be probably on the non-financial side. Maybe you can just shine some light on what that looks like, or what's the process for that?
Sure. I think broadly speaking, the governor's order doesn't prohibit you from filing an FED action for things other than this broadly defined non-payment. So if you've got a tenant that's destroying your apartment or somebody who's threatening somebody else and or otherwise violating major rules and deserves to be, that you would terminate the lease for cause in those situations, then you can go ahead and file that action. You're still going to have a problem with enforcing that FED action until after June 1st, unless there's some extreme justification for doing so now, but you can file that action now. And then Chris and I were just talking about, there's nothing that prevents you from seeking relief other than an FED action. So if you want to sue for monies that are owed in small claims or on a contract, you can go ahead and do that. You're not going to get relief very quickly, and you can't if you start trying to do an eviction attendant to that, you're going to run into big problems and possibly put yourself afoul of these orders, which is really not a good idea. We'll talk about the consequences in a minute. But those are possibilities that are still ostensibly open to you.
Gotcha.
What an investor might consider is if they think they are being fooled around with by a tenant who can pay rent but isn't paying them a dime, perhaps bring a small claims action to shake them back into reality. It's an option.
Right. But again, you're not going to be able to get into claims until, when could you actually file that?
That's not impacted by this moratorium order. The moratorium order speaks of bringing eviction actions and giving termination notices. But you cannot terminate a lease and collect rent as a debt.
Gotcha. Okay. So from timing, okay. So then what are some of the consequences for like a non-compliance for these actions? Depending on where you are, so.
Yeah, so I just alluded to that a moment ago. Under the governor's executive order, it's something taken under the emergency provisions, emergency statutes, and non-compliance by a landlord or by a tenant is a Class C misdemeanor. Pretty serious consequence there. It's much easier to prove that a landlord has violated it by pursuing a FED action for non-payment, but it is ostensibly, at least, the tenant is supposed to pay what they're able to. And failing to comply is likewise a Class C misdemeanor, although, as we talked about earlier, it's hard to prove. That said, there's additional sanctions that Multnomah County's ordinance has put into place that would apply throughout Portland and Multnomah County. And that's any landlord that's found to be in violation of that ordinance is liable to the tenant for 3 months' rent plus actual damages, so if whatever those might happen to be, plus attorney's fees and costs. So it's pretty severe consequence if you're found to be in violation of the Multnomah County ordinance.
I'd suggest this is a ripe avenue for tenant advocacy groups, so watch out.
Yeah, as we've I think told a lot of our clients,
especially with the attorney fee provision included in the county ordinance.
No, we've advised a lot of our clients that with what's going on in terms of, kind of the rulings and the, everything kind of changing and kind of shifting sands, that, get legal counsel on this stuff before you do anything. It's the penalties the consequences are severe enough, like you said, with the attorney's fee provision in there for that party. It's money well spent on the front end before you have to do it on the back end by doing something wrong and not, following the statute the way it's laid out. So I hate to say it, that's kind of been the market we've been in for the last couple of years in terms of that. So it's not unusual. I think what's unusual is things just kind of keep changing though, and how it's going to be. So
Absolutely.
I'm sure it's keeping you guys busy from that regard. What about, we do have some owners that own in both states. What about Washington? Are they in the similar vein as this? Or is it a little bit different?
Yeah, it's a whole different kettle of fish and would take another session, because in some ways it's even more complicated than here with, particularly up in King County and around Seattle. But there is a similar prohibition on evictions while the moratorium is in place. Prohibition on late fees, quite similar to Oregon's in that regard. The statewide one is on residential.
Okay.
There's a Seattle one that includes business. Some of the differences, though, with Oregon are the time frame. It started February 29, 2020, as opposed to ours, which started in April. There's an insert there, is that the tenant was somehow interfered with in its use of premises. For example, someone in the complex had COVID and the tenant isn't able to access its own premises for some reason. They don't have to pay rent for that period. And rent during this moratorium period, and I'm quoting here because it's kind of weird, is unenforceable unless the landlord offers a reasonable repayment plan to the tenant that is refused. So you walk that out, basically you don't get the full rent check or you don't get a rent check. Your claim for the rest is unenforceable unless you proffer to the tenant a, quote, reasonable repayment plan. I don't know what that is. And the tenant refuses. I don't know what that means if the tenant doesn't get back to you. Is that a refusal? It doesn't say. Or alternatively, if the tenant fails to comply with the plan. I suspect you're going to see a lot of disputes under that last provision regarding the obligation, or I should say the condition on collecting rent of offering a reasonable repayment plan. There's also both county and city ordinances, particularly around King County, so you would need to do another multi-layered approach if you have an investment property in that area.
Yeah, and just to add one little bit, the King County Superior Court and the other courts in Washington have indicated that they are basically just going to act in accordance with the state and local decrees, and so that means that the court, if it says you can't, if the Washington ordinance says you can't file an FED action, then the courts aren't going to let you file an FED action. If they say rent isn't enforceable, they're going to treat it as unenforceable. So they've indicated that they're going to comply.
Well, thank you guys for taking the time. We're going to get together again, I know, soon and kind of talk about some different pet tax that people could do to do this. But with all these changes, this is very interesting. I mean, interesting times in where we are. But again, with the state, the county, the city, then kind of going all kind of stair-stepping on each other. It's very confusing, I know, for property owners, management companies, in terms of what they can do and what the obligations are. So I want to thank you guys both for taking the time to do this. Hope your families are doing well, and we'll get together soon again. Thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.